I'm going to be presenting my case with you. Um, let's share my screen. I'll start from the beginning. My case study is about association for molecular pathology versus Myriad Genetics Incorporations. As you can see, it will be presented by me, Vanessa Sincere, for the class of Legal Environment of Business at FIU. My professor is Sus Ganske. Today is March 31st, 2020. In my appendix, you will find introductions, case background, the case facts, the case timeline, suggestion of the courts, and my thoughts on the case. Key terms, probably most of you are not too familiar with. I have BRCA1 and BRCA2. Those are two genes associated with breast cancer. And definition of patenting, protecting one's invention by filing for a patent at the US Patent Office. Next slide, it's about it's my introduction on the case. For decades, researchers have been trying to find a cure for cancer. This aggressive and deadly disease does not pity anyone. And it did not spare my family, because my grandmother was diagnosed with breast cancer back in 2018. As a 74-year-old woman at the time, she couldn't sustain chemotherapy. Not only does the disease break you down morally, but so does your body. Besides cancer, she was diabetic and hypertensive. Her health went down the hill very quickly. She couldn't fight, and she lost the battle against breast cancer. We would not want to know ahead of time, especially in my case, if you have a gene mutation associated with cancer risk. There are many companies nowadays that are developing genetic medical tests that can help you find out, including Myriad Genetic Incorporation. These are the forefathers of Myriad Genetics. We have Dr. Skolnick, Dr. Kevin Kimberlin, and Dr. Walter Gilbert. My background of the case. With the idea of developing genetic testing that can help patients to identify their risk, Dr. Max Skolnick and his colleagues, Dr. Kimberlin Kevin and Dr. Walter Gilbert, created Myriad Genetics. The company is located in Salt Lake City, Utah. As the name mentioned, Myriad Genetics is a diagnostic research firm specializing in genetic testing. Dr. Mary King from Berkeley University joined forces with Dr. Skolnick and find the actual location of BRCA1 and BRCA2, which was a very great breakthrough. So they invented a gene mapping for that breakthrough. Along with the other scientists, Dr. Skolnick filed for the patents of their discovery in order to protect it for anybody else to use, for nobody else to use. Dr. Skolnick filed for the patent. The patent became very controversial, unfortunately. As per law of nature, you cannot patent genes. The case facts. According to the case, seeking to invalidate Myriad genetic patent, the Association of Molecular Pathology filed a lawsuit against them. By invalidating their patents, Myriad will not be able to use its research to develop genetic tests, not provide treatment for patients. Hence, finding the location of those genes is in the best interest of Myriad to develop medical tests that can detect their mutation to identify the risk of cancer in a patient. This is found in Molecular Pathology and Myriad Genetic Case Court Case 2013. Furthermore, getting those patents will facilitate Myriad to successfully create a synthetic version of BRCA cDNA that is found in molecular pathology, the court case itself. According to the case, there are about 9 claims and questions leading up to this lawsuit, but only claims 1, 2, 5, and 6 are indicated. And details, claim 1 is a patent for the isolation of a DNA code that can command a cell to produce a BRC1 strings of amino acids. This is found in justicial law for the court case 2013. Claim 2 is a patent on the sequence of the cDNA nucleotides. This is also found in the molecular pathology and Myriad genetic 2013. Claim 5 is a patent for the 15 nucleotides of DNA contained in the isolation DNA in Claim 1. Molecular pathology and Myriad's genetic 2013. Lastly, Claim 6 is similar to Claim 5, and the remaining 9 claims are similar as well. Case timeline. The district court, by concluding that Myriad's isolated BRCA cDNA was a naturally occurring DNA, and April 13, 2013, the district court agreed with the appellants, so the patent was invalid. Quoted from Molecular Pathology versus Myriad Court Case 2013. The U.S. Supreme Court. John Roberts' court decision was half reversed and half remanded. There was different judges presiding over the case, and each one had different view of the Isolation Act of DNA for who can claim the inventor's right to patent. Judge Moore and Judge Lurie partially agreed with Myriad's claim. Judge Lurie found that altering the chemical composition of DNA strand would not change its information transmission. Quoted from the Molecular Pathology versus Myriad Genetic 2013 court case. Judge Moore himself couldn't completely agree with Judge Lurie's conclusion, but leaned more on the practice of how the U.S. Patent and Trademark delivers those patents. On the other hand, Judge Bryson concluded that an isolated DNA is not eligible for the patent, quoted from the Molecular Pathology versus Myriad Genetic Court Case 2013. On June 13, 2013, the final ruling of the U.S. Higher Court, which is the Supreme Court, held accountable that DNA, which is a product of nature, cannot be patented. However, cDNA, which is isolated, is eligible to be patented. Suggestion of the court. According to the court, instead of searching for an inventor patent, Myriad Genetic could have avoided all those issues by asking for a method patent instead. Furthermore, the Supreme Court held the same argument as the Circuit Court by agreeing that, quote, cDNA was not a product of nature as it eliminates codes that are not amino acids because any removal processes of such code will create something new. Quoted from LexisNexis, the court case 2013. My personal thought on this case, it is fair for a company to try to protect a product that it created and invented. I think it's fair. In the case of Myriad Genetic and the gene's mutations, there was no invention, as described above, that many other scientists came across that discovery already. The Supreme Court's decision in Myriad and its broad application, quotes, the Supreme Court's decision in Myriad and its broad application by the USPTO is just one of the recent case law hurdles and just one example of the general movement against a strong patent system that biotech companies must overcome, quoted from Wells and Cartier's 2015. Such a privilege of patenting a gene sequence by one company will seize the opportunity of another company to do the same. In life, I believe that you cannot rely on one medical research and cure. Companies, either commercial or medical research, needs competition. According to a peer-reviewed article, looking at the effects of changes in competition over time or analyzing the relationship between competition and productivity across many product markets, a large body of empirical studies finds evidence of a positive relationship between competition and productivity. Greater competition on the market leading to higher level of productivity. Quoted from Zilat's Q and Claude Nietzsche, 2018. I will stop sharing my screen. Once again, it was a pleasure to share my case with you as I went through an extensive amount of research. But anyway, I think you all guys work hard on your cases, and I just want to say, have a good night. I hope you enjoy my lecture. Thank you.